day to all. This is the latest complaint this claimant has lodged against the Accident Compensation Corporation staff in their inability to carry out work activities, specifically not making decisions allowing entitlements to be supplied. The staff have an inability to make decisions, removing the obstacle of earlier staff when they deliberately placed false misleading information on the claims file, so they achieved their own goals to increase their own incomes. Their work is to supply entitlements for persons who have cover due to personal injuries. In April 1981, while at work, I was involved in an accident that has left me with a permanent impairment causing an incapacity giving cover under the 1972 Act. The impairment is the loss of strength and stamina in the back muscles diagnosed as lumbosacral instability. The injury has developed when Accident Compensation Corporation would not allow the needed vocational rehabilitation to delay the development of lumbosacral instability, and then carry on in sustainable employment. In 1990, while working in employment, Accident Compensation Corporation completed and investigated to see if the employment was approximate for this person, taking into consideration the covered injuries, to see if the injuries were suitable and would not cause any unnecessary deterioration of the covered injuries. The covered injuries deteriorated, causing hospitalization as a consequence of the decision by the Accident Compensation Corporation staff member Mr. Lamart. Personal injury by accident. A. Includes I. The physical and mental consequences of any such injury or of the accident. 2. Medical, surgical, dental, or first aid misadventure. 3. Incapacity resulting from an occupational disease or industrial deafness to the extent that cover extends in respect of the disease or industrial deafness under Section 65 to 68 of this Act. 4. Actual bodily harm arising in the circumstances specified in Section 105B of this Act, which section was inserted by Section 6 of the Accident Compensation Amendment Act 1974. B. Except as provided in the last preceding paragraph, does not include I. Damage to the body or mind caused by a cardiovascular or cerebrovascular episode unless the episode is the result of effort, strain, or stress that is abnormal, excessive, or unusual for the person suffering it, and the effort, strain, or stress arises out of and in the course of the employment of that person as an employee. 2. Damage to the body or mind caused exclusively by disease, infection, or the aging process. So if the injury is a mental or physical consequence of any such injury or of the accident, it has cover, from the time of acceptance of the claim. This means that when the Accident Compensation Corporation representing lawyer made the statement, the judge recorded in his judgment as, while Mr. Macmillan and Professor Aldred referred to problems at the transverse processes of L1, 2, and 3, Mr. Swan had available to him the reports of both the specialists, found that on his examination some 4 years later, the appellant's problem was disc resorption and degeneration at the lumbosacral junction associated with an instability pattern at that level. Mr. Lucy Smith submitted the manner in which Mr. Swan set out his opinion had the effect that he was endeavoring to reverse the onus by requiring the respondent to show that the appellant was able to work. He submitted further that if Mr. Swan's conclusions were correct, this raised the possibility that the appellant had in the intervening period suffered another accident or that he was suffering gradual degeneration. This representative did not know the legislation well enough to practice law in this field. This representative could not read the medical report from the Accident Compensation Corporation appointed assessor. The medical report said while disc degeneration at the lumbosacral junction is common in the population without injury, it is not possible at this stage to definitely say that his current problem is not as the result of personal injury by accident and should, in view of the documented spinal injury in 1981, constitute a valid claim against the Accident Compensation Corporation. So the Accident Compensation Corporation is claiming the injuries had not been accepted when the assessor is advising the corporation he cannot find any error in the corporation accepting the physical injuries. Section 100 subsection 3 is the relevant section when Mr. Swan answered the question as to if ACC had made an error in accepting the injuries as described as lumbosacral instability. The section is worded specifically to prevent lawyers from claiming the corporation made an error when there is no error. Subject to Section 60, 5, 111, 5, and 112, 13, of this Act, any decision made by the corporation may be revised by the corporation if it appears to it that the decision has been made in error, whether by reason of mistake or by reason of false or misleading information having been supplied or by reason of fresh evidence or for any other reason, and the corporation may thereupon alter or amend any such decision or revoke the decision and substitute another decision therefor, provided that any such alteration, amendment, or revocation and substituted decision shall be deemed to be a decision of the corporation for the purposes of this section and sections 101 to 112 of this Act. Mr. Swan did not supply any new information, but confirmed the injury was correctly accepted. Mr. Swan could not find any error in the corporation accepting the injury. Any fresh evidence only confirmed the Accident Compensation Corporation was correct in accepting the injury as consequence of the accident or injuries. Then Section 355 of the current Act is to be applied. 355 Claims for cover accepted under former Acts. 1. A person who has had a claim for cover accepted before April 1, 2002 for personal injury covered by the former Acts continues to have cover, and this part applies accordingly. 2. Subsection 1. Does not apply if it is determined on or after April 1, 2002 that the person did not suffer personal injury covered by the former Acts. As the injury was accepted before April 1, 2002 the claimant has cover, and even though the corporation has carried out investigations since, they did not find the claimant did not suffer a personal injury covered by the former Acts, or the Accident Compensation Corporation has not obtained the necessary information to revise the acceptance of the injuries. But, the team manager is just another person who make up denial reasons. Here she is claiming that number 19,651 description for injuries out of 33,881 descriptions, is a symptom rather than injuries. There is several criminal acts listed as injuries, and one is TM8Z legal execution, no specific cause, but then it has been ordered by the authority of the country. In New Zealand it is illegal to carry out execution, so these actions are criminal acts. If there is a legal execution then it would not be an accident, so cover could not be granted. Maybe someone thought, it would be good to use something that is not designed to give a description to injuries due to accident would be good to carry out legal intervention. Would the team manager think that a legal execution is a symptom of an injury too? But, there is a specific injury due to the late effects of injury due to legal intervention. This will be the mental injury when the Accident Compensation Corporation employs lawyers and others who deliberately carry out activities to delay the supply of entitlements. If cover is not granted for a mental injury, then the deliberate acts that cause mental injury is a criminal act. This shows that persons in charge don't know what an accident is or what personal injuries are, no matter how personal injuries are caused. Here the team manager has decided not to add the injury to the claim, the injuries the accepted description of a number of injuries, when the description of injuries is a requested description of injuries by the Accident Compensation Corporation. Not carrying out the necessary investigations to see if Accident Compensation Corporation had correctly recorded the injury description on the claim is a deliberate attempt to cause a further loss by deception. Section 240 of the Crimes Act is clear, and it is her duty to disclose any wrongdoing by previous staff. This means that it is her duty to investigate and correct any error because the previous staff and ACC representatives had failed to disclose the correct facts. In Section 3 of the Accident Compensation Act, the purpose of the Act is explained, that is to ensure that the scheme is sustainable for managing personal injuries, while having the overall-riding goal of minimizing both the overall incidence of injury in the community, and the impact of injury on the community, including economic, social, and personal costs. Through a. Establishing as a primary function of the corporation the promotion of measures to reduce the incidence and severity of personal injury, in which the accident compensation is advertising, but not reducing the incidence of injuries. B. Providing for a framework for the collection, coordination, and analysis of injury-related information. Problem is the Accident Compensation Corporation is also collecting information that is not injury or rehabilitation related, while leaving out the primary cause of a number of injuries. This is including the mental injuries caused to persons when bullies control or try to control lives of others for their own agenda. C. Ensuring that, where injuries occur, the corporation's primary focus should be in rehabilitation with the goal of achieving an appropriate quality of life through the provision of entitlements that restores to the maximum practicable extent a claimant's health, independence, and participation. This part gives the widest and most benefit to an injured person. If one is not an injured person, then they are able to complete this throughout their life, and every person needs to make sure that those around them are achieving these goals. Having an impairment and incapacity means that it is the responsibility of the corporation staff to make sure that these goals are met. This includes that after an accident causing permanent impairment and incapacity, the person is earning or can earn to their maximum capacity. This means, low-paid employment is not an option unless one is in that employment when the incapacity commences. D. Ensuring that, during their rehabilitation, claimants receive fair compensation for loss from injury, including fair determination of weekly compensation and, where appropriate, lump sums for permanent impairment. Rehabilitation ends when the claimant is earning over their maximum capacity, or are able to earn over their entitlement level. Most persons' goal to earn to their maximum capacity stops when they retire, either semi or permanent. E. Ensuring positive claimant interactions with the corporation through the development and operation of a code of ACC claimants' rights. Positive is when claimants does not issue a complaint against the case manager. A complaint that show dishonesty, disregard for the legislation is instant dismissal. This would include not carrying out investigation to see if the claimant has a right to an entitlements. F. Ensuring that persons who suffered personal injuries before the commencement of this act continue to receive entitlements where appropriate. So the overall goal is to make sure the persons with an impairment, incapacity, or disability, has the ability to earn to their fullest, in employment of their choice, while making sure that all social needs are met. Her duty was to make a decision showing the Accident Compensation Corporation representative was incorrect in claiming the lumbosacral instability was not accepted by the Accident Compensation Corporation. And when Shelley Johnstone changed the injuries to read N141 pain in the thoracic spine because the Accident Compensation Corporation thought the claimant was involved in an accident on October 26, 1979, causing a complete paraplegia below T2 secondary to compression fracture T2/3 along with other injuries. Then there needs to be a decision made. Under Section 390. Revision of decisions under former acts. 390 Corporation may revise decisions. 1. The corporation may revise any decision specified in subsection 2, if it appears to the corporation that the decision was made in error, whatever the reason for the error. 2. The decisions are the following decisions made before the commencement of this act. A. Decisions made by the corporation, including decisions about premiums. B. Decisions not made by the corporation, but made in respect of claims that the corporation is responsible for managing. 3. In revising a decision, the corporation must apply the act that applied at the time when the decision being revised was made. Shelley Johnstone made a decision in error as she had taken injuries the claimant does not had or has and claimed that those injuries were the injuries covered. Mr. Wilson only recorded S1044 closed fracture lumbar vertebra, transverse process. The Appeal Authority decision of May 19, 1995 confirmed the healed fractures were no longer causing an incapacity. The decision confirmed Mr. Wilson was correct to add the injuries to the claim without a written decision. When the Accident Compensation Corporation agreed with the claimant and the treating providers, there was no need to make a decision agreeing with the decision, but then Mr. Wilson's own records show his belief as, the original decision was issued in response to Mr. Smith's request for a decision on cover for a number of conditions he believed should be covered. No previous written decision on cover had been issued. Mr. Wilson was case manager in 1990 when the covered injuries deteriorated because an earlier case manager made a false statement in the work activities the claimant could undertake. On page 42 of Judge Trapsky report he explains the Accident Compensation Corporation policy at that time. It is important to read this carefully as the words cover under the statute for their original injury or condition. This is policy as the legislation did not state cover is limited to the original injury or condition. In a more recent policy the wording is applying a similar attitude. It's important to review the cover decision at this point, to confirm the cover decision at the registration center was correct. As you build up a full base of information about a claim, if that reveals an issue that affects the validity of the original cover decision, though this is very rare, we need to identify this as early as possible, and take appropriate action. So Mr. Wilson reads the policy and accepts he should have made a decision in 1990, when he accepted the lumbosacral instability on receipt of the medical information. It can be only concluded that in 1990 Mr. Wilson did not make a decision for the specific purpose to deceive the claimant out of entitlements. He had no intention to supply entitlements. But also Pippa Hibbert is also causing a loss when she deliberately failed to make a decision for the purpose of causing a loss to the claimant. Again, it is her duty to make decisions, and this will require a revoking of the change of description by Shelley Johnstone in 1999, Mr. Wilson in 2006, and the revoking of the decision letter November 2, 2007, as it did not investigate to see if the covered injuries were, and are, causing the impairment and incapacity that prevents the claimant to return to his pre-injury occupation without vocational rehabilitation. The decision after the 2001 Act came into force is Section 65. 65 Corporation may revise decisions. 1. If the corporation considers it made a decision in error, it may revise the decision at any time, whatever the reason for the error. There will also be the criminal charges to the representatives acting for the Accident Compensation Corporation claiming the claimant's incapacity and covered injuries were accepted as age-related degeneration, or claiming there is no injuries, while claiming the claimant presented to the Accident Compensation Corporation injuries as age-related degeneration. 1. Though before presenting the natural degeneration due to age as an injury, the person would carry out the necessary research to see what is age-related degeneration. It is the degeneration that is natural, is not influenced by physical activity, work, gradual process, or accident. It happens to all equally, and it is solely due to age. Some injuries will cause the advancement of age symptoms and or cause the same symptoms as aging, but the injury will never become due to age. Degeneration written in medical documents is a condition that is not normal. The symptoms claimed by Professor Thies was back pain and stiffness. The symptoms presented by all other medical providers and the corporation assessors started with sprained spine that has deteriorated, causing loss of stability in the lumbar spine due to the weakened muscles as a consequence of the accident and injuries. Has Pippa Hibbert applied the legislation and made sure that the correct injuries and symptoms have been recorded on the claim file? More than likely not, as she had opened a new claim on notification. The injuries had returned to the same symptom as Mr. Swan reported to ACC in 1992. No continuous pain, no noticeable stiffness, but still have the loss of strength and stamina in the lumbar spine, preventing the claimant to return to the occupation at the time of the accident without having the workplace modified. The outcome of this investigation is to make the case management team make decisions under the approximate legislation, then carry out the criminal investigations, charging the persons for making the mistakes, charging the persons for supplying policy for the purpose of causing loss to injured persons, as the Accident Compensation Corporation legal representative has claimed to the courts.